If a child custody award in Utah has already been entered, that means the matter has been adjudicated by the court and may not be pursued further. That's known as res judicata. But in Utah, it may be pursued further by the same parties if the court finds a material and substantial change of circumstances has arisen. This requirement is statutory and found at Utah Code Section 30-3-10.4, subsection 2b. Whether a change of circumstances qualifies as sufficiently substantial and material to justify reopening the question of custody depends on the nature of the underlying custody award. The res judicata policy underlying the changed circumstances rule is at a low ebb in cases where child custody was determined by a settlement agreement rather than by a trial. Why? Well, as one court put it, an unadjudicated custody decree is not based on an objective, impartial determination of the best interest of the child. In such a case, the court does not redetermine the custody award, but adjudicates it for the first time. Thus, a lesser showing will support modifying a stipulated award than would be required to modify an adjudicated award. This means that the best interest of the child standard cannot swallow up the changed circumstances requirement or bypass it. Again, to quote the court, even an overwhelming case for the best interest of the child could not compensate for a lack of proof of a change in circumstances. The trial court may even consider pre-decree facts on a petition to modify an existing joint legal or joint physical custody or any other kind of custody order. So does the substantial and material change in circumstances requirement mean the court cannot look at what has happened since the child custody order was issued? Believe it or not, the answer is no. Even though Utah Code Section 30-3-10.4 subsection 1 provides that the district court may modify a custody award only if the circumstances, quote, have materially and substantially changed since the entry of the order to be modified, closed quote, that statute does not remove pre-decree facts and parental conduct from consideration. In fact, the opposite is true. Quote, when determining whether there has been a substantial change in circumstances, the district court will consider the nature and materiality of any changes in those circumstances upon which the earlier award of custody was based. Furthermore, the factors outlined in the subsections of the Utah Code 30-3-10 and 30-3-10.2, and which guide the court's original custody award, they include things such as the parties' past conduct, their past and present ability to cooperate with each other, any history of or potential for child abuse, and any other factors the court finds relevant. Nothing in the statute states or implies that, in determining whether modifying a custody award would serve the best interest of the child, that the court must confine its inquiry to the parties' conduct after entry of the original custody award. Or so they say. Rather than excluding the parties' pre-decree conduct from the inquiry, the controlling statutes invite the district court to include it. That's one way of looking at it. If that's confusing to you, you're not alone. Give us a call and we'd be happy to meet over lunch to discuss it more and how this might affect your specific case.